Hi, I'm Greg Dell with attorneys Dell and Schaefer, and today Stephen Jessup and I are going to discuss a recent case out of New York Federal Court against Unum Insurance Company, although in this particular case it was against First Unum Life Insurance Company because the state of New York has some different insurance regulations where you have to be licensed in that state, so that's why you'll often find while you have a national insurance company, they have specific entities that are incorporated in New York. So for our purposes, we'll just call them Unum throughout this discussion. But this case is kind of a really specific fact pattern, and the reason we want to bring it up is the insurance companies are known for having delays, and Unum sometimes engages in unnecessary delays. So let's talk about what they tried to do in this case and how the court ended up getting involved and what the court had to say.
Okay. With respect to this case, this is a ERISA disability policy. It was a denial of benefits. Unum had started paying benefits for a short period of time. They then cut her off. She filed her administrative appeal. During the course of that appeal, on the 45th day, her attorney contacted Unum to advise them that, hey, your time's up. There's no decision on it, which was responded to from Unum with a letter requesting a 45-day extension. This is very common. Many people contact us because the review of the appeal is taking too long. They want to know what their rights are because if an insurance company does blow the deadline, you do have the right to bring a lawsuit under ERISA. But this case had some interesting specific facts that the court had noted. In this particular case, what had ended up happening is in the request for an extension, Unum advised the plaintiff that we are requesting the extension based on we're waiting on requested information that they had sent to her treating physician. The caveat also is that they were going to toll the time frame before they started the review, so that 45 days could have been tolled indefinitely till they received that information. Well, in this case, 2 more months go by, there's still no decision, so they decide to file a lawsuit. Unum then, files a motion with the court to try to have the case dismissed for not satisfying all the administrative remedies under the policy, which is basically, filing the appeal, going through the appellate process. The court, in its opinion on this motion, and this has nothing to do with the actual, facts of the case and if they're going to decide for the plaintiff or for Unum, made a determination that Unum was not within its rights to toll the beginning of the review of the extension based on not receiving information from a third party. So it wasn't a request directly to the plaintiff because the insured does have a duty to provide information upon request. This was a request made directly to her doctors, and the court had determined it was really out of her control if the doctor's office wasn't going to send it. So that was part of the analysis it looked into. And then one of the other things which a lot of times you see in the letters from Unum or Cigna, any of the insurance companies, when they're going to request the extension, they'll say, should have a decision rendered by such and such date, which is a requirement under ERISA. Unum failed to also put that in the letter. So in this case, the court basically denied their motion to try to have the plaintiff's case dismissed for trial purposes.
So the biggest advantage here in this case, the good ruling for plaintiffs, is to say, look, when Unum says we asked for something and we're going to toll the statute, that the court basically said, no, you can't do that.
Correct.
You have your 45 days and then your 45-day extension, and you need to make your decision in that time frame.
Correct.
But the practical side of this, and a lot of claimants we have, go, oh, it's 45 days, it's been another 45 days, let's sue them. Mm-hmm. That doesn't always work out because look at this case. This person jumped the gun. Well, I don't want to say jumped the gun. They basically said to Unum, look, you didn't make a decision in 45 plus another 60, I'm suing you. 6 months later, the court rules, oh, well, Unum shouldn't have done that, and now we'll let the case continue. Mm-hmm. So, what was the big benefit for that claimant? Because, Unum wouldn't have taken another 6 months to make a decision, and maybe the claimant would have won. So you have to weigh.
It's a cost benefit. The court even said that the ERISA in and of itself and the regulations contemplate that an insurance company may not have all the information at the time it has to render a decision. And in this case, who knows if that medical information would have been incredibly helpful and supportive to the case. And once that lawsuit's filed, if no new information can come in, now the plaintiff may be without the benefit of the doubt of using that information to
Right.
present to the court to bolster their claim.
So it cuts both ways, because now that claimant is not going to be able to have that medical information in there. The flip side is I know the plaintiff's attorney is going to want to argue, well, you abused your discretion, and therefore the court should look at this de novo and review it and not give discretionary authority to the to Unum. And so that's one of the legal arguments, which is tough to understand in this limited video, but basically it could give the claimant just a review from the judge as opposed to deferring back to the discretionary authority of Unum. So that is one advantage, but you got to have a claimant who can really wait it out, is okay with no money coming in, is willing to say, if this takes a year and a half rather than waiting another 30 days or 60 days for Unum to make a decision, then by all means go forward. But from my experience, the practicality is, no, let's wait and see, and hopefully we win the appeal, and we don't have to go through a year and a half of litigation.
Yeah, and another thing the court also noted in this case was the request was made to her doctors. If the request had been made to her to get the information, then it may have been, certainly premature. But I think at the end of the day, we've gotten requests for information once an appeal submitted, hey, we're waiting on these records. And we always work to try to get those as soon as possible because if it's going to be helpful to the client, we want to provide it to the insurance company just so that review doesn't drag on and on and on.
Right. Well, if you have a case with Unum or any disability insurance company, whether you're appealing or you need to file a lawsuit, feel free to call any of our lawyers. We always offer a free consultation, and we look forward to the opportunity to speak with you.